Ruth Dice.
Thank you, Mr Speaker. I'm really pleased, as the Minister indicated, to speak in the second reading of the Canterbury Properties, Boundaries and Related Matters Bill. It might sound a bit dry to some people, that's not a reflection of the quality of the speech the Minister made. I just meant the topic generally, but actually it's really important for Canterbury. So I just want to acknowledge to anyone that's listening, if you think this isn't important, actually it is. In Canterbury, we had about 11,000 properties that moved at least 20 centimetres. That means that some people's boundaries are not where they used to be. Quite a lot of people's boundaries are not where they used to be, and that's caused some problems. So I totally agree with the Minister that this is an issue that needed fixing. In June 2016, we're fixing it. Excellent. It could have been a little earlier, but at least it's done now. I want to acknowledge the Minister who's just resumed her seat, not just for the contribution she's made in the debate, but for the fact that not just once but twice she invited Canterbury members of Parliament across the political spectrum to her office for a briefing that enabled us to get well on top of the issues and ask questions and get answers before the bill was introduced, and that is really appreciated. It is, as I said, a little bit dry, but it's actually very important to people who are affected by it, and for us to be able to get direct access to officials, ask questions and have them answered, made us more able to respond to questions from our constituents. And that's what's important in the end, getting accurate information from this place, particularly about significant changes to the people who are going to be affected by it. So I really want to acknowledge both those briefings that the Minister provided us with, and say that I would recommend to her that she spread the word amongst her colleagues, because it would be a really good thing if we could do things, particularly that don't have a political divide. It would be good if we could do them on a little more collaborative basis. The Minister indicated the number of submissions that were heard. I think that she didn't indicate enough, though, how important some of those submissions were. I guess they're all important, but in terms of the organisations that was represented, one was from the Christchurch City Council, obviously a critical player, along with Waimakariri and Selwyn in the space, as being the other elected representatives for the individuals who are affected by this mass land movement, and also the Canterbury. The Cadastral Surveyors Licensing Board of New Zealand, who did a written submission, didn't do an oral submission. Sorry, Mr Bridges. IT, Mr Bridges. So there you are. The response of the week. I'll get in the Labour notes for that one. That organisation represents the people who are responsible for drawing up the boundaries. They had a lot of really important issues to raise, particularly in terms of whether previous boundary surveying, post-quake, pre-legislation would be deemed illegal, the liabilities of such, and also provisions about other activities which weren't which were negligent, basically, and to make sure that negligence wasn't captured by the removal of liability in this legislation. Those matters seem to me to have been captured by the Select Committee in the main, and I commend them on that. I will be raising in the committee stage one issue which hasn't been captured by the Select Committee as a query, because it was raised in the submissions as a major issue by the Christchurch City Council. I can't find anything in the commentary or the amendments from the committee that refers to it, and that is the application of boundary provisions and watercourses. That was raised by the Christchurch City Council as a major issue. Doesn't seem to me to be responded. So I'll just give the Minister a bit of a heads up that when she's sitting in the chair during the committee stages, I'll be putting that question to her. She might want to read the Christchurch City Council submission again, because that's where the issue was alerted to me from, and just figure out why that wasn't responded to. It would be really helpful to get an explanation of that. We have a change in the committee the Select Committee has recommended a change in the time frame, so that the definition of Canterbury earthquakes was now extended to 14th of February 2022. Some people will know that we had another significant quake on the 14th of February this year. It's not the way that most people want to be moved on Valentine's Day. There are better ways of achieving that, but it obviously set a new time frame in terms of significant quakes. The fact that the time is now set out to 2022 is not an indication that we wish to have any more quakes till then. It just means that there will be security for surveyors, for homeowners and for planners right up till that time, and obviously if there are any more quakes between then and now, it will give Parliament time to produce more legislation to push it out even further or to amend this legislation. I hope we don't need to, but I think the change was very good. The change that has been made was very good because it does give that certainty, and I think a 6-year time period is sufficient in advance in terms of planning, whether it's subdivisions or whether it's alterations to a home or building a new property. It would allow all the key players the security to know that whatever they mark out as the boundaries will be the correct boundaries. The title conflict has been resolved, and that was another good change that the committee made that I want to acknowledge. A lot of people said that there should be a dispute resolution framework. That's another point that I was a little surprised the Minister didn't talk about much, because we know that there are some properties that will be negatively impacted by this legislation, and quite how they resolve their disputes or how they get any compensation as a result of that doesn't seem to have been adequately addressed, and I thought the Minister's contribution may well have clarified that. But the dispute resolution framework was raised by a number of submitters, but for some reason the committee decided not to go ahead with that. The liability for early surveys and boundary determinations was clarified. In what might be an interesting precedent setting, the committee decided that the guidelines issued by the Surveyor General would have no legal status, and I'm not sure if that has a flow-on effect to other guidelines that might be issued by the Surveyor General or by another government department or agency. For example, MB, if they issued guidelines, would this set a precedent for them not having any legal status? I'm not sure about that. A helpful definition of landslip was given by the committee, and that pretty well sums up the changes that were made to bring us to the second reading that we're now going through. So, Mr. Speaker, while I commended the Minister not just for her contribution but also for her process, I want to say that I was frustrated at the first meeting and expressed that frustration, and it wasn't resolved by the second meeting. In terms of the community organisations that were asked or informed or had this issue discussed with them, I think there were a lot of residents' associations that would have appreciated the sort of briefing we received so that they could have made a considered contribution to the bill. Not many people would read the Canterbury Property Boundaries and Related Matters Bill on the Parliament website, two unlikely occurrences, and think that might affect me, I should make a submission. But residents' associations are ideally placed to make that connection and involve the people who are affected by it. That wasn't done. The Minister took the Canterbury Earthquake Recovery Authority's advice and consulted with the Community Forum. The Canterbury Earthquake Recovery Authority is gone now, it's been disestablished, and the Community Forum has gone as well. But I want to say that that was not the appropriate body, and we should remember when we're trying to get information out to the public that we don't need to create bodies, that they are already in existence in our communities. They're well-informed, nimble, and I think the entirely appropriate people to have responded to. So we missed out on good community engagement. That may be the reason we didn't get as many submissions as we may have. But that's a lesson to be learnt for the future. I also want to acknowledge the work of the Local Government and Environment Committee. From the outside looking in, reading their report and looking at the submissions and the way they responded to them, it seems to me as if they gave the issues in this legislation a great deal of thought and consideration. I think they've done a commendable job, and I want to just conclude, Mr. Speaker, by saying that the submitters have really helped in this process. It's obvious from the amendments that were made. that the submissions contributed to a better quality outcome of the legislation, and that's, I guess, the process that Parliament should aim for. We should say, well, obviously the bill that we get at the start is the best that we thought we could do, the best the Minister thought he or she could do, but the Select Committee and the submitters can really improve it. So as a result of that, we've got a better bill to discuss in the next stages. People of Christchurch will welcome this, giving them some certainty after a period of a lot of uncertainty. Thank you, Mr. Speaker.